Welcome back to the Weekly Friedman, your source for the most essential information in the default industry. Earlier this year, we had an episode covering how to navigate complex New York SEMAs and erroneous satisfactions. Today, we're jumping back into the world of title curative, and we'll focus on how Article 78s can be leveraged to cure specific title issues. I'm Adam Friedman, managing partner at Friedman Bartolo, and I'm joined today by Friedman Bartolo Senior Associate and my good friend, Anthony Ortiz. Anthony leads our New York title litigation group and has extensive experience with Article 78s and has successfully assisted an endless list of satisfied title holders in having their necessary documents recorded. How's it going, Anthony?
Great, Adam. Thanks for having me back.
Thanks for coming back. So look, before we proceed, can you define title curative? Like what is that, and explain why it's necessary?
A title curative is the process or procedure taken to address defects within ownership of a piece of property. So the goal can be twofold. It's to correct errors within instruments encumbering that real property or remove unauthorized parties or filings on land records. This could range from satisfying open and ancient mortgages of record to expunging erroneous satisfactions, like we discussed in the prior episode concerning SEMA mortgages.
So it's pretty broad. I mean, what we're basically saying here is there's some problem with title. It could be anything, and we're going to fix it.
Yeah, exactly.
So what's Article 78 and why is it important?
Article 78, more broadly, is a proceeding against an agency or an officer. Within the context of title curative, we use Article 78 to overturn a county clerk's decision to reject an instrument for recording. The difference between Article 78 and Article 15, which is the more common quiet title mechanism used under New York law, is the nature of the proceeding. So in Article 78, a petition's filed as opposed to a summons and complaint. In our practice, we're solely proceeding against, in this case, the county clerk, whereas under Article 15, you have to ascertain and name all parties with an interest to that real property.
This sounds intense, right? So for someone who doesn't work in this industry, to say that we are commonly suing a county clerk sounds, I don't know, dangerous. Like you're gonna upset somebody. Is this overly adversarial when we're suing the county clerk?
No, not at all. And it's only in their official capacity. We're not seeking personal relief. And to date, I have yet to have a county clerk substantively oppose the relief I'm seeking. So the most commonly rejected document is a satisfaction of mortgage, a gap assignment of mortgage, or a corrective assignment of mortgage. Often a county will refuse to record the satisfaction of mortgage because there's a gap in that mortgage chain.
What's interesting here is what'll come up sometimes and what clients will ask me about is they'll have some concerns over this process, right? Because if a SAT's not recorded, there's a certain time frame within which they're supposed to record that SAT, which it's interesting because they don't control the recording. They could put it out there or they could have either attorney or whoever it is put it out there to get it recorded, but it might not be recorded timely. And then they have concerns that they're out of the timeline compliance to get the SAT recorded. So is that where this is coming up a lot of the time?
It's most commonly coming up after the loan has been paid off. As you say, the servicer, the investor is seeking to satisfy that mortgage because they have a statutory obligation to do so. And what they're coming across is issues with where the county clerk is refusing to record said SAT because there's that gap in the ownership chain. Somewhat paradoxically, they are also refusing to record gap assignments of mortgage and corrective assignments of mortgage for what I can ascertain is no real reason grounded in law. It's an administrative decision, and that's where Article 78 comes into play.
Okay. So what's the standard? Like when you're making this argument, I imagine it's a similar argument. Like there's a standard within which they must record if you do X, Y, and Z. So what is that?
So there has to be that attempt by the servicer to record that satisfaction of mortgage. There has to be a rejection by the county to accept that satisfaction of mortgage. The county clerk has a statutory duty to record and index instruments affecting real property if it's duly acknowledged or notarized and accompanied by the proper fee. So where a liener or a record owner presents an instrument for recording, if it's properly notarized and accompanied by that scheduled fee, the county clerk has a duty to record that instrument. There's no room for discretion here. But in certain counties like Orange and Putnam, a decision was made at the administrative level at some point along the way to not accept gap AOMs and corrective AOMs. And as I said, it's just not grounded in law.
So does that mean every time you want to record a gap, which is necessary every time there's a gap and you want to go satisfy? Like, are we saying every single time you must file an Article 78 in certain counties?
Not in every county. Article 15 is the more commonly used mechanism, but oftentimes the county will accept these gaps and corrective instruments. It's the counties where they're not accepting these gap and corrective AOMs that we're having to file these proceedings, specifically Orange and Putnam County most recently.
You would think that if everyone's constantly filing these actions, they would change their process, no?
You would think, but to date, I have not had such luck. They simply file a letter, so the county attorney is retained. They'll file a letter to the effect that they agree with the relief sought, or I should say they don't oppose the relief sought, and they simply ask that a certified copy of the order be recorded. So I'm having to file these petitions. I'm getting the relief granted. And when I then go to record said gap AOM, corrective AOM, along with the SAT to conclude the chain, I am also filing a certified copy of the order, compelling the county clerk to accept these instruments.
Can you file this action on more than one document at a time? So let's say it's one case where you can't get a SAT recorded, but you also need a gap AOM recorded. Like, can you file can you file one action seeking that both are recorded, or they're each their own action?
No, you can file a single action. So they often go hand in hand. In order to record the SAT, you first have to close the gap or correct either an assignor or an assignee on an AOM. So in order to successfully record that SAT, you also have to successfully record the gap or corrective AOM. So you'll attempt to record those just on your own. So the servicer will send their vendor or another agent to have these instruments recorded. And then after that refusal comes back for both instruments, I will then use both in support of that Article 78 to compel the county to record both.
Is this New York specific? I know Article 78 is New York, but like, is this problem New York specific?
I only practice in New York, but I would imagine there's a mechanism for mandamus relief in other states.
Okay, so recap. Article 78 is a valuable tool to be used when a county clerk is unwilling to record a critical document. Within the context of title curative relief, it can be used to appeal an administrative action in New York that the agency or offer is statutorily compelled to perform. Thanks for joining Anthony Ortiz and I on the Weekly Friedman, your source for the most essential information in the default industry. As always, if you have any questions or comments, please leave those below. Looking forward to seeing you next time, and thanks for tuning in.